Okay, good afternoon, everyone. Not sure if there's anyone still out grabbing some lunch, but welcome and thank you for joining us for our inaugural Spotlight on Financial Services series of presentations. I'd like to begin by acknowledging the Wurundjeri people of the Kulin Nation, the traditional custodians of the land we're meeting on today. I recognise the continued connection to land, waters and culture, and I pay my respects to their elders past, present and emerging, and to all all First Nations people joining us. My name's Jake Wilgens. I'm a partner in Hall & Wilcox's commercial dispute resolution team. A sizable chunk of my practice is in back-end financial services disputes and regulatory investigations and enforcement. And over the last, call it 9 to 12 months or so, I've been observing ESG and greenwashing assuming more and more importance in the regulatory space in particular. And I've done work for a number of clients in regulatory greenwashing, surveillance and investigations being undertaken by the corporate regulator. I think it's fair to say that this is the #1 area of enforcement and investigation focus and priority for ASIC at the moment. Which brings us to today's topic and our special guest speaker. It's my great pleasure to introduce Tomo Boston. Tomo's a prominent King's Counsel at the Victorian Commercial Bar. While maintaining a broad practice, Tomo is recognised as an expert in environmental law, including climate change litigation and regulatory investigations. He also acts in director's duties and disclosure matters concerning ESG risks and also in litigation involving contractual risk allocation for pollution and product failures. He's published over the last couple of years or so a series of really insightful articles on climate change litigation and greenwashing. Particularly focusing on ASIC and some of the types of greenwashing cases that ASIC may bring in future. And I understand, Tomo, that you're acting in some confidential greenwashing matters presently, which unfortunately you can't discuss, but I am, and I'm sure everyone in the audience today is very keen to hear your views on ESG and greenwashing and really what the financial services sector can expect to see moving forward from both a civil litigation and a regulatory perspective. Now, greenwashing is a huge and multifaceted topic, and no doubt Tomo could speak on it for many hours, but for today's purposes, Tomo will be focusing on some key areas that are most relevant to the financial services sector, as time unfortunately doesn't permit an in-depth exploration of every aspect of this very wide-ranging topic. If you do have any questions for Tomo on any ESG or greenwashing issue, then please raise your hand at the end of the session during question time, and Jacob Lewis will bring around the roaming microphone. If we do run over a little bit, feel free if you need to leave to duck out, but equally, if you can stick around and are prepared to do so, we're happy to stick around a little bit longer. This session is being videoed, so if you do have to leave early, you'll be able to catch up and watch the video, which will be circulated separately. Without further ado, could you please join me in welcoming Tomo Boston KC.
Hello, everyone. Thank you, Jake, for the invitation. What I'd like to do to start with is just to give everyone a bit of an overview. As everyone here probably realises, there is a lot of movement in this area, and it moves so rapidly, it's very difficult to stay on top of everything that happens on a day-to-day basis. So what I'd like to do is just spend 5 minutes to give you a quick snapshot, just to bring you up to date about what's happening in the financial services area in terms of greenwashing. In the regulatory space, you probably would have all seen just recently, there's a net zero authority that's just been announced, and that's a very good thing. There's going to be a designated body which is designed specifically to help the transition to net zero, and they're looking at reskilling work as one of their particular focuses. You would have seen the safeguard mechanism that's just been published. Now that's been around for a little while. That's been around since 2016, but it's starting to have some teeth now in 2023. So that's going to apply just to specific facilities. So it won't apply to financial products as such. And then of course we have the Climate Change Act. And we then have a very interesting thing. We have a legislation which makes 43% 43% reduction in emissions by 2030 to compare to 2005 levels. Now, what's really interesting about this area is that there is so much confusion about everything. So I think a lot of you would have known that in relation to the Glasgow Pact, it was 45% by 2030 against the 2010 levels. So immediately there's a disparity again between what the government has legislated and what was the Glasgow Pact, the international standard. And this is part of the problem in this area. There seems to be such confusion and about the different standards that apply and how they are to apply. In relation to the guidance, ASIC has got a really good document, and I recommend that all of you read it. It's Info 271. I think if you haven't read it, you should read it. It's a fantastic document. There are some problems with it, but it is in terms, it has laid down the plan as to where ASIC will pursue. And as you were seeing, unfortunately, with Mercer and BME and Diversa and Vanguard, they are actually examples out of Info 271. So if you are seeking to avoid greenwashing, like the title of Info 271 says, you should read that document. You've seen ASIC with its regulatory powers. They're using what are less than, they're regulatory instruments such as the stop orders. So they've used the stop orders in relation to the breach of the DDO. Now, I'll talk to you about the DDO if you're interested in that area. I think it's an area of risk that has not yet come to fruition. I think it's going to be an area that ASIC will pursue, because the target market determinations that I see in the marketplace are poor, and they don't actually articulate precisely how it is that the ESG objectives of a particular fund, for example, how it meets the objectives and the needs of the target market. And I think that's a real area. It's not in Info 271, but I think you need to be aware of that. Infringement notices, you've seen those. So again, that's just a misleading deceptive conduct provisions that are being pursued there. And you've seen, I said, Talu and Vanguard, et cetera, What we haven't seen yet is damages cases. We've seen damages cases in America. So that's not regulatory, that's more civil. So we've seen them in America, and I'll take you to one of those in a minute. And but I think we have to be prepared for that inevitability. Once the pathway to a damages case is established in Australia, I think the floodgates will open, and you'll see plaintiff lawyers becoming more prominent in this space, because at the moment the risk is regulatory. There's no doubt about that. But plaintiff class actions and probably NGOs like ACCR, market forces, these sorts of organisations, I think you're at risk of being pursued by those organisations. And then, of course, pecuniary penalties. And unfortunately, I have to keep mentioning Mercer, but pecuniary penalties I think, is going to be the next ground. I think the civil penalty regime will be engaged. And I think that anyone who is found guilty of greenwashing will probably be pursued by way of a proceeding rather than simply the infringement notices which have been done in the past. Now, you probably would have seen in America, I'm not sure if you have, but there's an anti-ESG movement that's happening over there. That hasn't happened here yet, but there's a real pushback against ESG. That might be on political lines though, because it's Republican states versus Democratic states that are doing that. So you just got to be aware of that. And I think some companies are also pushing back. I think BNP Paribas is also pushing back. They've been pursued by Greenpeace, and they've brought a case against them to have them withdraw the material that they published in relation to their breaches of their Paris Agreement obligations. So there's a lot of development in this area. One issue that will be prominent today is taxonomy. Now, taxonomy is just a classification. So green, ESG, carbon neutral. That remains a real problem. It's very important in this area, because if everyone in this room knew what green meant, or ESG meant, or carbon neutral, we wouldn't be having as many greenwashing issues as we now do. The problem is those words are so loaded, they don't have a standardized meaning, and that becomes a problem. And I'll take you to that. So you're probably all aware of, there was Abrahams and Commonwealth Bank. McVeigh and Rest and O'Donnell and the Commonwealth Government. Now, those cases were sort of the precursor litigation. They were all by interested parties. They were pretty much funded by NGOs. But what they were seeking to do is to chase those organisations in relation to a failure to disclose in relation to the climate change risks. But what we're now seeing is a morphing of that. We've sort of gone away from that because they were quite difficult cases. And now what we're seeing is the attack on transition plans and net zero pledges. Because in that way, if you understand what that is, and I can talk a bit about it at the end if you want, but a lot of companies are saying that we're going to be net zero by, let's call it 2040, and by 2030 we'll be, say, call it 43% reduction in our emissions. The problem in a lot of cases is they're not supported by a transition plan. So how do they get there? How do they actually get there? Some people have transition plans, and those plans are not audited by a third party. And that's the problem. So if you're in a fund, for example, and you have a ESG, a company that says that it has a transition plan which is vetted by one of the many organisations that are out there, how do you satisfy yourself as a fund manager or an issuer of a product that is in fact what they say is in fact what has happened? How do you do that? And if you don't do it, are you at risk of greenwashing? Now, these are really difficult issues that are not resolved at the moment, but hopefully at the end of the day, what I'm hoping that you'll get out of this is that you can ask the right questions. Not so much that you have all the answers, but you have the ability to be informed about what questions you should ask, because that's a really important thing. Because a lot of people, very sophisticated organisations, are getting caught by this greenwashing, this surge in greenwashing. And I think part of the reason is because they're not asking the right questions, or perhaps maybe their marketing department is running the show in respect of the disclosures. So you have to be aware of that. You've all probably seen Client Earth, and who has been very active. I met with them last year in the UK. They are a formidable plaintiff organisation. When they reach our shores, there will be some very interesting litigation that they will pursue. They have brought that very imaginative derivative action they've brought against the Shell directors personally, and we're going to see that happen here. We're going to see directors being pursued. The difference in our legislation to theirs is that they actually have a duty to have regard to the environment. We don't have that here, but the due diligence obligation that we have here, I would be surprised if that doesn't cover that in the current context. In relation to super funds, hopefully you're all across the Butler-Sloss case. Have you all come across that English case? Okay, it's called Butler-Sloss and Charity Commission. It's a 2022 case. It's really interesting. So one of the issues that a lot of trustees and super funds have concerns about is that can they invest along an ESG line as opposed just to a purely financial line? You know, and is that permissible under their obligations? You know, their obligations to the beneficiaries. And if they're caught by the CIS Act, then are they entitled to do so under their covenants to invest, for example? Now, that case is interesting. I'm not going to go into chapter and verse on it. It's essentially, it was a specific charity that had a specific purpose. The specific purpose was to improve the environment and to eradicate poverty. And they asked the court for a direction as to whether or not they could just solely invest in ESG products or Paris-aligned products, Paris Agreement-aligned products. And there were some very interesting comments on that. I can give you the citation at the end, but I just wanted to touch on that just to bring you up to date upon what's happening in that space. I saw on the list that there were some trustees and super funds here, so perhaps that's an issue that you should be aware of. So there you go. Hopefully, hopefully you're not overwhelmed by all of that. Look, one of the issues, as I said, one of the big issues in this area is taxonomy. You know, so the question, if I polled here, I think I'd be surprised by the answers. Does anyone here think that net zero and zero emissions is the same thing? Is it the same thing? No. Yeah, that's right. It's not the same thing. So net zero was defined last year for the first time, or beginning of this year, by the United Nations. And it says that effectively what net zero is, that you have to reduce as close to zero as you possibly can your net emissions, And then once you get to that, you can offset by a permanent offsetting process, whether that's CCS or if I'm speaking too much jargon, please just tell me. CCS is carbon capture and storage, or some other offset. You could buy an offset, for example, in a forest offset. Now, that is what a net zero is. You've got to try to reduce as close to zero as possible. And then once you get to that point, then you can do an offset, whichever way that is. Now, zero emissions is what it says, zero emissions. It's just no emissions. You're not making any emissions from your production, manufacturing, whatever it is. Now, those words are often confused, and it's a greenwashing haven for regulators. So if you, for example, see a fund which says they're only going to invest in zero emissions products or financial products, your first thing you should say is, well, is that right? Because how is that possible? It's very difficult to establish zero emissions. It's possible to establish net zero. That's a different question. But then with net zero, there's two problems that you need to, there's two issues you need to be aware of: permanence and additionality. So you must remember these words. So when you're examining a net zero representation, permanence is this: a lot of people offer schemes, whether or not forest carbon offsets, but they don't last. So you buy, for example, a carbon offset, say in the, let's call it the Kakadu, and you expect that you need it for 20 years. At the end of that, at the end of the first year, they decide to, let's say, dig it up. So there's no permanence there, yet you have made an assumption that it'll be there for 20 years. So that's the first problem you need to think about in relation to a net zero promise or representation. The next is additionality, and this happens often. I'll give you a live example. There was an area called Hawk Mountain in the United States. It's a forest. It hasn't been felled in 100 years. Yet they were selling carbon offsets or carbon credits to Disney, to Louis Vuitton, to all these big brands. But the argument in the area is that they're not actually adding any further carbon reduction out of the atmosphere. So it's not additional, and so it is frowned upon from a scientific perspective that is not an adequate means by which or valid carbon offset. So you have to think about these things, right? So additionality and permanence, and these issues are so prevalent in the area that the largest certifier of forest carbon offsets, a company called Vera, and it was an investigation that happened earlier this month, said that 90% of all of their carbon offsets were in fact didn't provide what they said it would. So, this is a big problem. So if you've got a company coming to you and saying, okay, we've got as close to zero as possible, and we've got this carbon offset and it's from Vera, well, you need to ask that question. Even if it's not from Vera, you need to ask that question. Is it permanent or is it additional? You need to ask that. Now, I'm not going to go through all of them, but the other issue that you need to be aware of with net zero is scope 1 and scope 2. Now, does everyone understand those concepts? So scope one is what you burn, okay, to produce your output. Okay, so if I'm a factory, for example, right, it's the energy that I'm burning myself, right, to produce my outcome. Let's say it's a widget, for example. Scope 2 is what I buy, my energy that I buy in. So that's from Origin Energy, that's from whoever your provider is. Okay, that's your scope 2. Scope 3 is where all the debate's about. Scope 3 is your upstream and downstream. So your supply chains and your distribution chains. So it's broad. So for example, you take a law firm, if you're looking at their scope 3, me driving my car and parking it in a car park to come into this building, if this was my law firm, that's scope 3. And the largest part of most organisations' emissions is scope 3. Now, the problem with scope 3 is it double counts, right? So my scope, the law firm scope 3 is my scope 1, for example. So there's this big ideological argument going on about whether or not you should or should not. Now, you might have heard about the task force on financial disclosures, on climate change financial disclosures. They're recommending, ASIC is recommending that you need to account for your scope 3. But in any event, what I'm saying to you is that when you're looking at a net zero claim in relation to a financial product, you have to ask yourself, does it account for scope 3? It's really important, right? If it doesn't, ASIC seems to allow you to say, we are net zero, but we're only talking about scope 1 and scope 2. That seems to be permissible. They don't seem to have a difficulty with disclosure. So if you're saying that my net zero claim is actually only in relation to scope 1 and scope 2, that's okay, it seems. Obviously, there needs to be a lot more context about that, but that seems to be okay. The problem is, though, if you say net zero and you don't say it excludes scope 3 if you don't account for scope 3. Okay, so you have to ask that question. Green's a loaded word. Does anyone think green is sustainable? I don't know what it means. There's no definition. There's no definition of this. Sustainable is a word which is sometimes used as synonym for net zero. It's a problem. These words are problems. And so this is really important, because the number of funds or the number of superannuation products or the number of companies that use this label, we are a sustainable financial product, we are a sustainable company. And it staggers me that occurs. I mean, Natalie was telling me she was driving in today and she was saying that she was listening to a company who was saying that they were, what were they saying, Natalie? They supply 100% green energy. Yeah. So clean energy, that's another phrase. So you'll see that within companies. And so super funds, for example, there's this debate going on at the moment. Super funds, large super funds are saying that we can invest in fossil fuel companies because we can influence the way in which they can transition to net zero. And if we do that, we can still describe our product as an ESG product. Now, I saw this commentary in the Australian Financial Review in March, and one of the company, the super fund, is a large super fund who was the author of that view. I think that there's going to be litigation on that if that's the position that they hold, because that may not be the case, because you have to be very careful how you use the language, influencing changing behaviours, whether or not that constitutes ESG, that's in my view, you don't have to go there. You don't need to do that. You don't need to say that, and you've just got to be careful what you say. The last one I want to show you is the bottom, ESE and ESG. Now, this goes back to the taxonomy. So ESE is picked out of Info 271, which is ASIC's document about how to avoid greenwashing. Now, ASIC has tried to give clarity there, and I'm not being negative, but I just need you to know about this. ESE is environmental, small s is sustainable rather than social, and large E is ethical. Now, ASIC seems to have introduced a different concept there, right? It's not the same as an ESG, right? Their definition of greenwashing picks up the ESE definition. So does that mean that ASIC is not going to chase you for social, the S component of the ESG? And does it mean also that ASIC is not going to look at your governance? It may not be their purview, but does that mean that they're not on their radar? So is all ASIC saying that when they look at a fund or a potential greenwashing instance, they'll only be looking for environmental, which is what we all understand as the E of the ESG, S, which is sustainable, which in my view is a synonym for E in some contexts, and then ethical. And you would have seen that the ethical component is probably picked up by cases where they've chased the sin stocks, where there's a negative screen for a sin stock. So, so maybe that's what they're harkening back to, because the old concept in the days when there was corporate social responsibility was a concept known as ethical investing. And perhaps that's what they're picking up, because they've sort of gone after the sin stock failures as their first port of call. So, so it's interesting to see what, where that's going to go. Okay, there's other things there, but I'll let you read through that. The next slide really is just about taxonomies and how they can be useful. As I said to you, the main one today that I wanted to focus on is it'll help you prevent greenwashing, but there is no statutory definition of greenwashing. There's no cause of action of greenwashing. all we have at the moment is the simple discussion the provisions of all the different acts, the ASIC Act and the Corporations Act, which deal with misleading and deceptive conduct in relation to a financial product. And that's your safe haven, right? If you're trying to work out what it is that you're doing wrong in relation to a promotion of a financial product or an issue of a financial product or anything to do with the dissemination of a financial product to a retail investor, your first and final port of call is the corporations legislation of the ASIC Act. So don't get confused by all of these things. Now, just to give you an idea about the taxonomies, when I was preparing this, I thought this was an interesting slide. I hope you can see it's a bit small, but there's 11 countries on that list that have adopted a green taxonomy. My Google search told me there's 200 countries in the world. So it's a very small number that have done so. The two big companies, and all of these companies on there, these countries on there are like Sri Lanka, Colombia, Indonesia, Kazakhstan. You know, EU, of course, has a taxonomy, which is important. UK hasn't adopted its taxonomy yet, but it's released some consultation papers. So we aren't at the stage where we have a uniform standardized approach to identifying and regulating greenwashing. Now, just to give you some idea quickly, at some point we're going to get some legislation, I think, in relation to greenwashing. What I wanted to do was just give you some idea of what's happening in the EU. This is the EU's version. They have a environmental objectives, which involves climate change mitigation, adaptation, etc. And then to be sustainable, you have to meet the 4 criteria. One of them is your economic activity contributes to one of those objectives, and your economic activity does no significant harm. And that's an important concept because I think it's going to be picked up, you know, somewhere else other than the EU. No significant harm is really important because what it tries to do is it allows you to, as a product provider or issuer, to look at other issues other than E and an S, right? So it doesn't have to be the only thing you can look at in order to be a sustainable product. And that gives it scope for growth. And that's really important. And I suspect that what's going to happen is we're going to have some version of that. Indonesia, for example, has a very different approach to this. They have a a traffic light approach. It's either red, amber, or green. If you're green, you're green. Amber, maybe. Red, obviously, no. You know, so there's wide approaches to all of this. Some of you might have read that there's, in the EU, they identify financial products according to these articles, Article 8 and Article 9. Now, as you can see, it's very narrow. It's a financial product that promotes E and S characteristics, among other characteristics. That's one of their versions. And then the next version is that have a sustainable investment as its objective and has an index as a reference benchmark. So that's only 2 types of particular financial products that are available to be classified as sustainable. That's pretty narrow, I think, and I'm not sure that we'll adopt such a prescriptive approach, but that's just to give you some idea of where things might go. The Treasury consultation paper, we're working on a sustainable finance framework. I suspect we're going to get some more legislation out of that. They're talking about a standardized, internationally aligned requirement, but again, what that means, I'm not really sure at this stage. I thought it'd be useful to tell you about the ESG and how it started and the content of ESG. It always surprises me that people don't understand what sits within, what is the content, what's the components that sit within the E, what's the components that sit within the S, and what's the components that sits within the G. Like everyone talks about ESG, but what sits within E? What's an E for the ESG? Now, the other thing that you also need to understand, I'll come to that in a minute, but the other thing you need to understand is how ESG is used. Now, it's used in a number of ways. There's a large piece of irony in all of this. Large companies, financial companies like Deutsche Bank and Morgan Stanley, etc., they were the originators of this ESG idea. It started in about 1999, 2000 by the United Nations. They came up with an idea that business could help them achieve their objectives of peace and development. And so they asked all these large financial organizations around the world, how can you, and to use the language, better integrate ESG factors in asset management, securities, brokerage, services, and associated research functions. And all of these companies, large companies, jumped on board, and they put ESG at the forefront of all these investment ideas and the manner in which they conduct themselves. And the irony in that is that they're the ones who are now kicking and screaming, saying that ESG is not useful, but it's their idea. And that's the irony. It's quite interesting. But anyway, it's supposed to have started off as an investment analysis tool. It's now a risk management tool. It's checked whether or not your company's sustainable or its corporate responsibility. And then it's also now used as a preference for investors. So it's used in different ways. So you've just got to remember how it's being used, because that's also important, because in addition to the confusion about what the term means, what the components are, people aren't understanding correctly how it's used. And that, again, leads to a greenwashing risk. I'll just skip over this quickly, but in the first column there, they were the examples contained in the document that the United Nations produced with the assistance of all those financial institutions. And what they did is they gave examples of the content of ESG. In the second column, what I've done is just added a couple more. The point of the matter is that ESG, or the E and the S, continue to be evolving, right? They're not static. And as I said to you, what I think ASIC is doing is it's allowing you to define what your E is and what your S is, as long as you disclose it. So for example, and this is the really important thing. So when you say a fund is ESG, does that mean that you're saying that the company that you've invested in, for example, it meets the climate change and related risk, it meets the need for toxic releases and waste, it meets the need for new regulation, et cetera, or is it just one? And that's the questions you have to ask. So it's simply not good enough just to say, oh, my fund is ESG. But what are you talking about? What component of E and what component of S are you talking about? Because the other thing you'll remember, G doesn't have an objective in itself, right? G is the manner in which you achieve your E and your S, right? It's governance. So that's not an objective target in itself, right? And then the difficulty, of course, is how do you measure S, right? You can measure E, you can say, I can emit 1,000 tons of CO2 equivalent per year, for example. But how do you measure S? How do you measure that you have a good work health and safety program at your employment? How do you measure that? And how do you impose that as a measure or a characteristic or a factor that you include in your statement that you're ESG, you have an ESG fund? So there are things you've got to think about. And it may be that when you say you're an ESG fund, you're not actually saying that you're an S. You're actually saying you're just an E. And within E, you're actually saying you're just one component of that. I'm getting a lot of blank looks at you. I hope you're all understanding that. The point of the matter is that it's not fixed, okay? So you can define it in the way you want, but you must disclose, right? And I understand that for people who are issuers of products, that is not always easy, right? But I was saying to Jake at the start of this, before we started this, is that we're at the start of this process. It might be that what we have to do is that we have to over-disclose, and then as the market matures, we'll go back to a more refined and more concise statement. And that happened with the PDS. Some of you are too young to know that, but when the PDS first came out, it was a huge document. It dealt with every single risk you could imagine. And now it's this short form PDS you can put out. It's a more refined document. It's very concise. We're not at that stage yet. So we might have to deal with the stage where we just over-disclose, put everything in, and let ASIC say to you, well, hang on, that's too much. It's confusing the marketplace. And then once they're at that mindset, then you can start refining it. And I think we're going to have that evolution, but right now we're not there. As I said, again, just the G is an enabler. It's the manner in which you achieve your E and S. And so you just need to remember that. That's the way was how it's supposed to have started, and that's the way it's been done in, say, the UK, right? So G is not an objective in itself. And so that brings you back. So when you say you're in ESG, do you in fact have, let's say, workforce diversity? And how do you measure that? You know, so you just need to think about all these. Yes, you have to think of each of the components. Okay, staying with taxonomy. This is Planet Trackers. This is one of these NGOs that have put out information. Now, when I looked at this, I must confess I didn't know all of these green type of things. Greenwashing, I knew greenwashing, obviously. Green crowding, green lighting, green shifting, green labelling, green rinsing, green hushing. I'm sure by the end of today, there'll probably be another green something. And tomorrow there'll be another one, and again another one. Don't worry if you have never heard of these terms before. As I said to you, your safe haven is the legislation. That's all we've got at the moment. And your safe haven, if you're working in the financial product space or insurance space, is Info 271. That's your safe haven for the moment. What these terms are useful for is to identify a few examples. So if you are in your business and you want to, and you are trying to identify a particular problem or whether or not you might fall foul of the legislation, you can look at these because they're quite interesting. And a lot of greenwashing is not simply that you have what they call a brown product or a brown financial product and you pass it off as green. Those, in terms of the organisations that are in this room, in terms of the organisation that Hall and Wilcox represent, that's not going to be the type of case that they deal with. You know, they're just rogues, right? It'll be the case where you have on the line, on the margin. That's the case where you have, and Mercer's a classic example. You know, they're on the edge of it. You know, I'm sure they made every attempt to establish that what they were doing was green, but they didn't quite get there. You know, and that's the area where you're at risk, right? It's not just the passing brown off as green. It's passing maybe light green as dark green, or not even whatever the aqua, maybe into green or whatever the colour is, you know. So that's the grey area, right? It's the grey area where you're at risk. And I think that you've got to make a concerted effort to make sure that when you're in that grey area, you look at these examples, for example. And I'll take you to some because some of them are interesting. So green hushing is an interesting one. So one of the attempts by companies now to avoid greenwashing is to say nothing about their green credentials, right? And that's a problem. That's a problem, I think, from a perspective of getting ready to achieve net zero by 2050, right? You have to, at some stage, tell the marketplace, at least from a reputational perspective, what your plan is and what your targets are. And a lot of companies are starting to say, well, we're targets as a result of doing that, so we're not going to do that. So it's called green hushing. The stat is that less than half of the ASX 200 companies have a net zero pledge. That's interesting, isn't it? I was surprised by that. I thought that there would be more. You know, that's only our top 200. You know, I think there's 2,000 listed companies, I think, from memory. So we've got a long way to go. You know, there's a lot of companies that are listed that are potentially part of your funds or part of your investment strategies that don't actually have a net zero pledge or a transition plan. That's very interesting. You know, so that comes back to what I said. You know, if you say that you have an ESG program or plan or financial policy or whatever it is that you have, you've got to be careful as to what company you've got in your fund, for example. So the other one is green rinsing, and this is happening as well. Now, I'm not taking an ideological perspective. I'm just telling you some facts, right? So green rinsing is Coca-Cola and Pepsi-Cola are identified as the largest plastic polluters in the world. Now, when I was preparing for this, I got some statistics and I was flabbergasted by them. They 1 million plastic bottles are bought per minute every year, every day of every year. 91% of them are not recycled, and they end up in our oceans, etc. So I'm not taking an ideological view, but I'm talking about this is the fact. So if that is the case, and Coca-Cola is one of your companies in your fund, then are you an ESG fund? I mean, otherwise, Coca-Cola is a very financially sound company. It's one of the largest consumer goods in the world, most recognizable brand. The other thing that's been said against Coca-Cola, for example, is that they are trying to sell their plastic rather than recycle it as fuel for kilns in the third world. And they spruik that as a really strong environmental policy they've adopted. But can anyone think about what the problem might be? So they're selling plastic to kilns in these developing nations, and they're burning them as fuel. Now, the problem for that is that, of course, it has the impact of getting plastic out of our oceans and out of our landfills. But the problem also, though, is that by burning plastic, it's causing a horrendous health issue for the local community. And so on the one hand, they are doing some form of E, but perhaps they're not satisfying the S component of the ESG. And so the reason for the example is that you have to think a bit more about what's being put to you and how what's occurring might impact in other aspects. So, and that's a very sobering example. But anyway, banks. I don't know if there's any banks here. Banks are going to be in the gun. I think they're the next company that are going to be in the gun. What they're doing is that they are seeking to influence the net zero development or transition of companies by investing in a particular way or lending them money. Now, the example I've got there is really quite interesting. So NAB has funded an extension of the Newcastle port, but that loan came with a requirement to have environmental improvements. Right, and that seems to me at first blush a very good thing. The problem is that 1.5% of the greenhouse gas emissions come from the coal that goes through that on a yearly basis. So then the question becomes, is that loan actually a sustainable loan? Is that loan actually an ESG loan? So you have to think about it in a broader way, because it's not simply you've discharged your obligation by simply saying we're going to tag along some requirements to impose environmental improvements, and we don't care about what happens one step after. Now, the other question you have to ask yourself too is from a litigator's perspective, which is Jake and I and some others in the room are, is that if that occurs, is it actionable? Is it actionable in terms of a greenwashing? Is it actionable in terms of any of the provisions that will answer to a financial product being misleading and deceptive? And that's an interesting question, but if it's not actionable, it may not mean that it's not greenwashing in a broader sense. And this is the concept that I think sometimes people get confused. There's greenwashing in a broader sense and then greenwashing in a litigation cause of action sense. Right, because morally, depending on your ideological stance, what NAB did is probably doesn't sit well with you. But from a cause of action stance, a litigation stance, there might not be anything that's actionable about what they did. So just to understand that distinction. Would you like one more example, or I'll move on? One more example is green lighting, and I'll give you an example of our company, Glencore, which is co-listed. I think it's listed here and also in the UK. So this is the other thing that these companies are supposedly doing. Now, again, these are all allegations, right? So it's not proven. So on the one hand, Glencore releases all this information about, it's going to It's aligned to Paris. It's going to have a 15% reduction by 2026 and 50% reduction by 2035. So that all sounds really good. The difficulty, though, is that Glencore is making application for an expansion of its coal mines in Australia. So on the one hand, it's highlighting all the good things it's doing in terms of its reduction, but then it's seeking to expand its production of or its coal mines. Now, I believe that case is the subject of complaint. The EDO has made a complaint to ASIC about that, and I think Client Earth is also supporting that. So these are actual examples where these NGOs are seeking to pursue companies like this, and when you look at it objectively, there is a difficulty if you are on the one hand saying we are going to hit a particular target at a particular stage, but then on the other hand, you're also seeking to expand the very thing that increases your carbon emission. Now, as again, it's not an ideological thing, it's just a factual thing. You can't on the one hand expand your coal operations which give rise to greenhouse gas emissions and then on the other hand say that you're reducing. So these are things you just got to think about. I've just given you some of the provisions there. They're the likely provisions. A lot of them are misleading, deceptive conduct. 769C, I think, is from memory, is a reasonable basis. You have to have a reasonable basis for saying, making your statements in relation to your financial product, and they're the provisions that you're most likely to get. So in your space, right? They're not all of them, but like for example, PDS has a civil penalty provision as well. So you've just got to be aware of what the provisions are so that you can design and distribute your product in a way which sits with those obligations. So I've got a question for you, and I'll ask you at the end. So you've got two funds. This is just hypothetical. One's ESG-A and one's ESG-B, obviously. Okay, in ESG-A, you've got a negative screen. So a negative screen, you normally exclude what are called sin stocks. So when you compare that to the positive screen on the other side, under the Fund B, you've got a positive screen, 100% in sustainable agriculture and manufacturing. And the question I have for you to think about is, can an ESG share fund be either negative or positive? Is it equally permissible for a fund to be negative as it is to be positive? That's the first question. The next level is investment in biofuel palm oil company. So in that negative screen, despite the fact that biofuel, which comes from palm oil, or what can come from palm oil, is not a weapon, alcohol, tobacco, or fossil fuel. Well, hang on, it's probably weapons, alcohol, or tobacco. Does that still mean that a biofuel can be something that you can include in your ESG fund? Now, the reason I raise that is because, again, palm oil, or the production or the harvesting of palm oil, results in a huge amount of deforestation worldwide. So deforestation is an E. So if a company is presenting itself as a palm oil producer, which results in deforestation of areas, is it in fact an ESG share, ESG company? The next one is the investment in Coca-Cola, and I told you about their issues in relation to their plastic. So Coca-Cola, from a financial perspective, is in fact a solid financial investment, but it has issues again in relation to its plastic. Now, what about a company that doesn't have a transition plan to meet the Paris Agreement, but is otherwise not a weapons, alcohol, tobacco, or fossil fuel company? Can that be an ESG in your ESG fund? And what about Holcim? Cement. Cement has been historically one of the greatest polluters, but now it has transitioned out of that and it's still in it, but it's now has a transition plan to align with Paris. And this is an interesting question. So if a company was historically a large polluter and now seeks to meet Paris, but sits within your fund, is that permissible in terms of defining your fund as an ESG? So there's historical pollution, or historical emissions, but now it's seeking to reduce its emissions in the way which is prescribed by the Glasgow Pact or Paris, and it conforms with all the legislative requirements, so like our Climate Change Act here. Can it sit within your ESG fund? On the other side, ESG shared Fund B, so sustainable agriculture and manufacturing, that's what we're seeking to do. Can you invest in Oatly, for example? I don't know if you've been following the problems Oatly's been having. So soy also has two problems. One leads to deforestation, and two, the production of soil has waste products which need to be treated before they can be entered into the sewage. So is Oatly truly an ESG company, even though it produces plant-based milk alternatives? You know, because cow farming or milk and dairy farming is considered to be one of the most serious polluters or greenhouse gas emitters. But then Oatly puts up its alternative and says we do it by soy. But soy leads to deforestation. Production of milk from soy results in waste effluent which needs to be treated before it goes into the sewage. So are they an ESG company? IKEA has been only uses, it's the largest user of wood in the world, and it only uses wood from, it has this classification called the Forest Stewardship Council classification. That is the gold standard. It's the hardest thing to get for your wood. Is that permissible when they find out that some of the wood has not been properly audited and in fact taken from old growth forest? So these are live examples I'm giving you. This, I'm not making this up. This is, you know, these are documented examples. But IKEA is otherwise a sound financial investment. And then investment in a company that doesn't report its Scope 3 emissions. The thing you've got to remember, like most companies, the largest component of their emissions is Scope 3. Most fossil fuel companies, the largest component of their emissions is Scope 3. It's up to 90%. So Scope 1 and Scope 2 only account for 10%. So it's minor. So if a company is otherwise in, say, sustainable agriculture, and it doesn't release its Scope 3 emissions targets or reductions, is it an ESG product? Now, ESG ratings, I'm sure you've all come across ESG ratings. That's the final one. Now, ESG ratings are problematic, right? No two ESG ratings are comparable. The methodology for any ESG rating is different across the board. So there's no standardization. And from time to time, they change their methodology. And as a consequence of that is it's very difficult even to compare the same product from year to year. So the question is, when you have an ESG rating like that, are you an ESG fund? So I'll come back to that at the end, and you can all tell me what you think. The true to label. So as I said to you, Info 271 is a really good document. It sets out examples. These are the things you should avoid in order to obtain, to avoid greenwashing. True to label, there hasn't been an Australian case yet, strictly. There's two cases, Goldman Sachs and BNY Mellon. Now, what's interesting about these cases, and I think this is the next stage, and I was saying this to Jake, the next stage I think is, it's not going to be simply what is completely client-facing, right? They're going to look behind your client-facing information. They're going to ask you, you have said to your client, you have an ESG proprietary system to identify ESG products, for example. Have you in fact used that, right? In Goldman Sachs case and BNY Mellon, monstrous financial companies, they didn't actually do that. And they were both fined large sums. I think Goldman Sachs was 4 million, is it? Yeah, 4 million. And BNY Mellon was 1.5 million. You know, so I think that's going to be the next phase, right? So it won't just be your PDS that goes out. It won't be your marketing on Facebook or marketing on your website. They're actually going to look behind. That might be the next stage. They're going to have a look at what you're actually doing within your organization. Now, Jake and I were talking about this. ASIC is really well resourced, you know, in relation to this space. You know, in the past, you would almost have comfort in saying, well, they'll only come to my front door and won't go inside my building. I think now they have enough resources to actually come into your building and spend some time within your building and look exactly what you're doing. And I think that's the real concern for organizations like yours. You know, so you have to get your house in order, you know, and simple things like knowing what the marketing team is doing and as opposed to the legal team and how they combine, you know, those sorts of simple issues are really problematic. That was the downfall in Goldman Sachs. Their marketing team wasn't talking to their compliance team. And that's what happened. They got a $4 million US fine. So you just have to be careful about that. Features, reasonable grounds, again, this won't surprise you. If you make an ESG statement, you have to have a reasonable ground for saying it. There's nothing magic about that. There's nothing novel about that. Future Super just happened, I think, a week ago. So ASIC served them an infringement notice. Just look at what they say. A Facebook post. So it's interesting. ASIC's gone behind. It's gone to something like a Facebook post. But look at what they say. They say naysayers don't join together and move nearly 400 million out of fossil fuels. No evidence that they actually moved their $400 million from fossil fuels into some sort of ESG sort of fund. There's no evidence of that. Yet they make that statement. Yeah, it's in terms of risk management, that's an extraordinary thing to have occurred. You know, so you know some of these errors are what low-hanging fruit. You know, that could have been avoided. Black Mountain, again, no reasonable ground. So Black Mountain comes out and says, "Oh, we're going to have this industry-leading ESG scorecard, net zero carbon emissions." They don't have any allocation of funding. They don't have any design work, but yet they say that. They were lucky to get an infringement notice. You know, I think if ASIC, in a year's time, if this occurs again, I think ASIC will bring a proceeding. Talu, again, same sort of issue. No reasonable basis, a fine of $53,000. So they've got no modelling, no investigation. Sequestration is just a CCS, which is a carbon capture and storage. It's just a version of that. So they're talking about them having carbon neutral electricity. Now, carbon neutral electricity, if you hear that ever, just run a mile. It's not, there's no such thing. You know, the use of language to associate neutrality or carbon neutrality with electricity is a problem that Santos, in a way, has with its gas. You know, they talk about clean gas. So Santos is being pursued for that. As soon as you start using clean in front of any sort of energy producer, I think you have a problem. You know, in terms of a general red flag, that's a general red flag. So you're screening. Now, I hope you all know what negative screens are. So you basically say you exclude certain stocks, and they are traditionally the sin stocks: gambling, tobacco, military, and alcohol. They're normally the four. That's been added to. You can pick whatever sin stock you want now, it seems, as long as you disclose it again. But here's the series. So in 2017, the SEC, I think they fined Pax World $500,000 because they had a negative screen again with sin stocks, and then they purchased sin stocks. Now, here's an interesting question to think about. A lot of these companies or these funds that say that they don't invest in sin stocks will say, it's not a blanket, I won't invest in sin stocks. It's, I won't invest in a company that derives, let's call it 5% of their revenue from a sin stock. So is that an ESG product? What's the answer to that? You know, because if you're trying to avoid sin stocks because there's some sort of moral concern or ethical concern or fossil fuel concern, but yet you're still investing them as long as they don't derive more than 5%, for example, of their revenue from that company, from those areas, industries, then can you still call yourself an ESG fund, for example? So sometimes it's important to just understand that, to recognise that that's what they do in relation to these sin stocks, and just be aware of that. Because again, it leads to a greenwashing risk. Diversa is our example. And so they had a negative screen as well. And again, so have a look at their negative screen. It's different to the traditional. So it's polluting and carbon intensive activities, financing or supportive activities which cause E&S harm, and then poor corporate governance. So that's a different sin stock, that they're trying to exclude. So it's a different negative screen, I'm sorry. So ASIC didn't seem to complain about that. They were just concerned about that they in fact had invested in those types of companies. And then Mercer, I know there's a Mercer representative here, so we'll just let that poor person alone. But but again, if you read what's written there, again, anyway, we should probably move on. So prospectuses, I think, are also another area of fertile ground. I've got an American case there for you. It's a damages case, so that's really interesting, right? So we don't have damages cases yet in this area, but we will, I think, at some stage. So Bellow's just the class plaintiff. So look at the language they've used there. Sustainability is at the core of our business and actionable in our products. Sustainability at Oatly is far more than achieving certain key performance indicators and corporate policies, blah, 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 right? So that's what's in their prospectus, right? And as I was saying to you, one of the problems with production of soy is that it produces a really toxic effluent and you have to treat it. And so what we don't have yet, and I think this will be an interesting area that might happen, the Spruce Point management, they're just like an NGO. So what they do is they go around and they examine companies. So where a company says they're ESG or green or whatever, they'll go and examine all their statements and then they'll produce a report. And they're now so famous or infamous, whichever way you want to take it, that every time they produce a report, there's a price drop, right? A share price drop. Now that's the problem we have in Australia for the class action lawyers. There hasn't been a significant share price drop that's attributable to, say, a non-disclosure or a problem with the ESG classification. And so that means then we are unable to, the plaintiff class action lawyers are unable to actually bring their cases because there's no loss. But in America, in this case here, in Oatly case, there was in fact a loss and they've pursued that. And it's still in progress, but that gives you an idea of where things might go. You've got to be careful with your prospectus. PDS actually says that you need you have to explain or disclose the extent to which your environmental and social and ethical considerations are taken into account. So you all know that. And then there's the guidance there. So Vanguard's our example. Now this is an interesting one as well, and this is again an error that people might fall into. So Vanguard was tracking, Morgan Stanley's index, and Morgan Stanley had a negative screen. But the information included in Vanguard's PDS was that the negative screen only related to excluded securities in production, manufacture, or significant sales. But in fact, what the index was just the exclusion of production and manufacture of tobacco, not the exclusion of sales. And so by not actually saying that in their own PDS Vanguard, they were deemed to be misleading. And again, that's just simply tracing it through, working out what exactly the screen is saying. And so they were fined by ASIC. I'll quickly touch on this. DDO, most of you must know that by now, your DDO obligations and also your TMD. You've got to be careful with your TMD. I'll give you an example. ASIC has given an example in one of their documents, their guidance documents. You need to be aware of it because I think that it's going to be an area that ASIC's going to pursue because it's also an area in which companies can get themselves into trouble. So this is an example of its a class identification in a TMD, or target market determination, I'm sorry. A retail investor with a high risk return profile that is seeking income growth and or income distribution over a long-term investment timeframe from an investment that incorporates ESG risks and which can vary from a small allocation to a standalone basis. So the point in that description is that it just says incorporates ESG risks. So what risks are they? So if it's your target market determination, what particular risks have you identified? ESG. But what about ESG? ESG has components. Is it the S as well? Or just the E? I think that there's a real chance that ASIC's going to look at this when you try to, when you design your ESG sustainable products. They'll look at that, what you've done, look at your TMD, because there's been 26 stop orders so far this year. And they're going to say, well, who are you identifying? Who are you actually identifying in your target market? Now, you've got to be careful with your TMD, because TMD and the DDO came about as a result of concern that disclosure was not sufficient, right? So they want you to actually comply with your DDO obligations. They take it seriously. So you need to be really aware that when you are looking at TMD, if you have any responsibility for a TMD, you need to be cognizant of the fact that it needs to identify the class by its likely objectives, financial situation and needs relative to the product you're selling. So how do they meet? How does the ESG product meet the needs of the particular target market? And that's actually a pretty hard question to answer, you know, but you've got to do it. Because I think there's a real gap, because I've read a number of these TMDs and I'm astonished at how general they are. And the guidance that ASIC has said is that they need to be specific. It can't be general guidance. It cannot just be a general statement. So they've warned everyone, and I don't think people are taking the message. So I think that this is going to be a real area. It's not in Info 271, but I do think that it's going to be a real problem. Okay. How'd I go for time? Oh, sorry. If you want to discuss that case, the case study, which I put up, and just to tease that out, I'm happy to. Or if you just want to ask a general questions, I'm happy to take those questions as well. Everyone gave me very blank looks, so I hope.
Sorry, I just wait.
No, I said that because their focus is on the E, S and E, that they may not be concerned with the S and the G. Is that what they're signalling? That's what I was saying. But they probably do have some purview over the G. But the Info 271 seems to be focused on environmental, sustainability and ethical, which is not an ESG. It's not an S and it's not a G. So the question that I asked in the paper that I wrote that was, well, what is it that they're seeking? Are they actually signaling to the market that S and G is probably not in their purview? You know, it might be, and I can't remember, is it Adrian, you were asking me the question about jurisdictional issue between ASIC and ACCC, and I think there are jurisdictional issues in this area as to which regulatory authority actually has the power to regulate some of these issues. The stock standard financial product, of course, falls within the purview of ASIC, but there are issues on the edges which are not quite clear as to whether or not it falls within the purview of ASIC at all, and whether or not they actually have the power to regulate it. So, and that's an issue that needs to be teased out at some stage. Not here, but certainly in some litigation, I think jurisdiction will be an issue.
You were talking about the media release from the super funds who said, you know, they had an ESG focus. I mean, clearly they would think of themselves as impact investors using
Yep.
their size and scale and influence
Yeah.
to have an impact on ESG things.
Yeah,
Is it permissible to say we seek to have an impact on
Yeah.
ESG,
yeah,
but not just we are ESG?
yeah, that's right. You can say you can have an impact. And I think there's clear statements in Info 271 that says you have to, one, tell them why you decided, or sorry, how you're going to go about having that impact. And two, you've got to report on it,
Yeah.
right, and adjust it, right? So that's what you've got to do. So you can, I think the bottom line is disclosure. You know, that's what you've got to do. You've got to disclose.
Well, on that,
Mm.
I reviewed a TMD once for an ESG portfolio
Yeah.
where it said we seek to invest in ESG stocks, but our portfolio managers have complete discretion to not invest in ESG. I mean, that's not misleading. They've disclosed, apart from the label itself,
Yeah, yeah,
they have complete discretion to not invest in ESG stocks.
yeah, yeah.
But it seems to me it's not true to label if it's called an
It's
ESG.
not true to
manager.
label. That's right. I think so.
So that's where disclosure can't really cure a headline defect.
No, that's right. That's right. And there's going to be many permutations which you can raise, which don't quite fit the, you know, the answer that or the issues, or sorry, the guidelines, right? But, and disclosure won't cure everything. But as a whole, what they're pushing us to do, I think, or pushing our clients to do is actually to disclose, right? Because they're not defining anything, right? They're not saying green means this, sustainable means this, ESG means this. They're just saying that's a product design issue. You design it the way you want, but you tell the market what it means, you know? And this is where I think also the problem is that how do you compare ESG-A to ESG-B? You know, one's a negative screen, one's a positive screen, but they're both ESG. And that seems to be permissible, provided you tell the market, your target market, what it is that you're selling them, you know? And I think that's kind of common sense in a lot of ways. Yeah.
Hey, I was curious about the TMD.
Yep.
So as you mentioned, it needs to be specific and accurate. Is there a method or idea on how can we constantly ensure that it's specific and accurate, as we know investors might join a specific type of product and not be exactly based on the TMD that was published at the beginning? How do we ensure that it's actually these types of investors that are joining this product, or actually measuring them constantly, so we can update it to be an appropriate measure?
I think there's an obligation from memory in the DDO that requires you to update your TMD. I don't know about the frequency, but look, the bottom line is that if you are aware there's changes within your target market and you fail to do anything, or you fail to do a reasonable review, a review in a reasonable time period, I think you have problems. You know, in this climate, I think you're going to have a problem, you know. But the problem for all of this, like the taxonomy, there's no hard and fast rules, right? But what I think ASIC has always done in respect of all its regulatory conduct is they require you to make an effort, right? They actually do. It's as simple as that. If you can show them that, you know, if they come knocking on your door today, but you've got a planned review 2 months down the track, that might be enough. Or if you've just done a review and you missed something because it wasn't known publicly or for whatever reason, then that might also be okay, you know? So I think you've just got to do what is reasonable in the circumstances, which is a very much a lawyer's response. But, you know, that's as clear as I can make it. Yeah. Yeah.
Thank you. As a lawyer, excuse me, in this space, I'm just curious how you would balance the requirement to disclose clearly, concisely, and effectively in a PDS, as opposed to, as you're saying, over disclosing in terms of ESG and what that means for your fund. And so how would we advise a client that really wants to disclose what their ESG focus is, so they go on for pages and pages and pages about that?
Look, I completely agree. Like I said to you, when PDSs first came in, you know, you used to have like 100-page document PDSs, right? And over time, once the market got more mature, you know, they became, I think they're like 25, 30 pages now. I think we're at the stage of the 100 pages. You know, I think it's probably best at this stage to do more than less. And I think that's my recommendation. Obviously, you still have to be clear. 100 pages is not concise, but you certainly have to be clear. And you're being 100 pages because there are what you consider to be reasonable risks that are in your product that need to be disclosed. Now, when the market becomes more mature and when there is more clarity about what the regulator's views are on ESG and green and sustainable and net zero, we might be able to pare all of that back, but there are ways in which you can disclose 100 pages in, 30 pages of it, for example, just by being a bit more concise. I don't think it's necessary for you to continue to say that, for example, here, it's a negative screen, it's not a positive screen, but we still consider it to be a ESG product, but it doesn't, you can, there's a certain limit without trying to confuse, because you still have to be clear, right? So, look, it's very hard to do it in the ether. All I can recommend is you've got two very good lawyers here. You can you can retain them, so and they can give you some advice. But look, it is a balance, and it's hard. It's an evolving space. There are no bright lines. But like I said, what's the most important thing is that I hope what you've learned from today is just to ask the right questions and to understand that, right? And that will also inform what you disclose in your PDS. Because if you were sitting in the shoes of a retail investor looking at the PDS, what might you like to understand, right? So that you're not misled. And that might not necessarily be 100 pages. So does that help you? Maybe not. Yeah. So anyway, all right.
Tomo, just one last question. I'll take the liberty of asking it. This is touching on the point that you've made a couple of times about really in Australia, ASIC's focus being on about being that you get to set the parameters of what it is that your product does.
Yeah.
And as long as you clearly state and identify that, and then you do what you say you're going to do, that's going to be sufficient. Do you think there is a point at which the degree of qualification or the limitations that you do include in your PDS or whatever else will erode the headline, if your fund's called the ethical fund or the ESG fund or something like that, to an extent that the disclosures themselves, while accurate, will be considered insufficient to deal with the fact that you're holding out this fund as being an ethical fund or something when it's not in fact the case? And do you think that ASIC will, despite the lack of an agreed taxonomy, start to take action in relation to products that are labelled in that way?
Yeah, I mean, I think Info 271 does talk about that. I mean, I think it's very clear that if you've got a headline claim, ESG fund, for example, and then you try to water that down through some language later on throughout the PDS, for example, or prospectus, I think that's a problem. That's a problem in the current view of ASIC, but I think what might happen through this Treasury consultation that they're doing to try to come up with their own framework, I suspect that what might happen is that they might adopt something similar to what is happening in the UK, where this idea of using particular phrases, green, ESG, whatever, they're going to have standard language, which you can only qualify for and you don't have to explain further, right? So you need to satisfy the regulator that you fit within that particular category. And once you do that, you just can then use the phrase. And that might be what might happen in future. So instead of you explain it in 100 pages, the UK's proposed taxonomy is that there's 3 layers. So I can't remember off the top of my head. There's 3 levels. One is 70% ESG. One's an improver, and one is an alternative, investing in alternative technology, or something along those lines. And anyway, you can't use that classification. So you can't use ESG, you can't use green, you can't use sustainable, but you must use these 3, right? And then once you fall within it and you're certified by the regulator, that's it, right? And so that might get away with the issue about having to re-qualify down the headline statement, and it might get around your issue about whether or not you have to put in 100 pages. you know, to explain everything. So, but I think the space is going to evolve really quickly, because I think in July of this year is when the sustainable framework that the Treasury is working on will close, the consultation periods will close, and I think pretty soon afterwards, because it's been pretty slow. I mean, to be honest, I mean, this issue's been bubbling around for some time, you know, and we still haven't had any agreed taxonomy on anything, you know, so, but anyway, all right. Good luck with it all.
Thank you. Thank you very much, Tomo. Thanks to everyone for coming along. So everyone who registered for today's event will be sent a link to the recording and of this and also other sessions during the Financial Services Week. And that'll include contact details. So if you have any questions, please reach out. I think tonight there's a session on the networking event and panel discussion around navigating the market for property funds, if anyone's interested in attending that. So please speak to our events team. But otherwise, thank you very much for coming along, and enjoy the rest of your day.